The time was exactly 6:42 in the morning when the sound began. It was a low, guttural groan of stressed metal, and the rhythmic, ominous beeping of a vehicle in reverse. I was at my kitchen window, watching the last of the morning mist burn off the long grass at the edge of my property, a cup of black coffee warming my hands. The sound was wrong. It didn't belong to the quiet symphony of birds and distant traffic that usually scored my dawns. I set my mug down on the granite countertop, the ceramic making a soft click in the stillness, and stepped onto my back porch. There, not 50 yards from my house, was a large, greasy-looking tow truck, its amber lights flashing silently in the pale light. It was hooking up to my old Ford F-150, my truck, the one I used for hauling mulch and taking my dog, Buster, to the river. And standing there, directing the operation with the imperious gestures of a battlefield commander, was Brenda Miller, president of the Oak Hollow Homeowners Association. She was wearing a pink velour tracksuit, a color that seemed to violently disagree with the serene greens and browns of the morning. One hand was on her hip, the other pointing a perfectly manicured finger at the tow truck driver. She hadn't seen me. She was too absorbed in her performance of authority. I didn't shout. I didn't run out there waving the arms. I simply went back inside, retrieved my phone, and walked calmly across the damp lawn. Buster, a golden retriever of advanced years and gentle disposition, trotted alongside me, his tail giving a few uncertain thumps against my leg. The tow truck driver, a young man with a weary expression, saw me approaching and paused, his hand hovering over a lever. Brenda turned, and a triumphant smirk spread across her face. It was the look of someone who had finally, after a long campaign of attrition, achieved a decisive victory. "It's about time you woke up, Mr. Henderson," she said. Her voice was sharp, carrying an abrasive edge that cut through the morning air. I noted the deliberate use of the wrong name. It was a petty power play, one of her favorites. "My name is James Peterson." I ignored it. "That's my truck," I stated, not as a question, but as a simple declaration of fact. "Not for long it's not," she chirped, the smirk widening. "It's parked on HOA common area in violation of Article 7, Section 4 of the Covenants. No vehicle storage on common property. We've sent you 4 notices." I remained silent, my gaze fixed on the heavy chain being looped around my truck's front axle. I raised my phone and began recording, making sure to capture the truck, the driver, Brenda, and the wide expanse of the field where my Ford was parked. The field that was, according to every document I possessed, my property. Brenda's eyes narrowed at the sight of the phone. "You can record all you want. It's not going to stop this. This is official HOA business. You've been a thorn in the side of this community for years with your projects." She gestured vaguely at my well-maintained workshop. "This is what happens when you refuse to be a team player. The truck gets towed. Then the fines start. Then the lien. I will see this through, Mr. Henderson. I will personally see to it that your defiance cost you this house." She identified herself and her authority, just as I knew she would. "I am Brenda Miller, president of the Oak Hollow HOA, and I am authorizing this removal." I didn't say another word to her. I turned my attention to the driver, who was now looking profoundly uncomfortable. "Young man," I said, my voice even and calm, "for the record, could you please state your name and the name of your towing company?" He hesitated, looking at Brenda. She gave a sharp nod. "It's, Mike, from County Line Towing," he mumbled. "Thank you, Mike," I said. "And for the record, you are towing this vehicle, a Ford F-150, license plate number Echo Victor Tango 797, at the explicit direction of this woman, who has identified herself as Brenda Miller." "Yeah, she called it in," he confirmed, his discomfort growing. "I see," I said. I lowered the phone. I looked at Brenda, at her face flushed with victory and self-importance. I looked at my truck, a machine I'd owned for 15 years, being treated like an abandoned piece of junk. And I looked at the long, unmowed stretch of grass it was sitting on. A piece of land I had walked every day for 25 years. A piece of land I knew better than she knew her own reflection. She thought this was the end of a long argument, the final move in a game of neighborhood chess. She had no idea she had just kicked open a door that had been locked for 2 decades. She had no idea who I was, what I did for a living for 40 years, or the exact nature of the ground she was standing on. She had no idea she just buried herself, her HOA, and her entire reign of petty tyranny. But before I tell you what I did next, I should probably explain. This wasn't a sudden storm. This was the hurricane that had been brewing offshore for years, and Brenda Miller had just steered her little boat directly into its path. I am a retired man now. For 41 years I was a jurist. I spent the first 15 as a prosecutor, and the last 26 as a superior court judge for this very county. I didn't handle traffic tickets or petty theft. My world was contracts, property disputes, corporate malfeasance, and municipal law. I was the man people came to when the arguments were no longer about emotion, but about the unyielding text on a notarized document. My life was a fortress built of paper, precedent, and process. My late wife Eleanor used to joke that I could find a loophole in the 10 Commandments. She was the heart of our home, the vibrant color to my grayscale world of legal briefs and statutes. When she passed away from cancer 5 years ago, the silence in this house became a physical presence. The quiet I had once cherished as a respite from the courtroom became a constant reminder of her absence. I filled my days with woodworking, gardening, and caring for Buster. I sought peace. I avoided conflict. I wanted nothing more than to be left alone with my memories and my routines. This house, this land, was our sanctuary. We bought the 5-acre plot 25 years ago when it was still considered out in the sticks. It was the last parcel of an old farm, bordered by a creek on one side and undeveloped woodland on the other. I designed the house myself. Eleanor planted every tree in the orchard. The long strip of land where my truck was parked, the part that ran along the access road, was what we called the meadow. It was where she wanted to plant wildflowers, but never got the chance. It was, unequivocally, part of the 5 acres described in our deed, a fact I had verified with a professional survey before we even broke ground. Then, about 10 years ago, the development came. A company bought the woodland behind us and put in the Oak Hollow subdivision. We weren't part of it. We were an island of old county land, adjacent to their new, meticulously planned community. At first it was fine. The neighbors were pleasant enough, but with the houses came the homeowners association. And with the HOA eventually came Brenda Miller. Brenda was one of the original homeowners. A real estate agent by trade, she had a certain polished charisma that worked well on people who weren't paying close attention. She volunteered for the board, then became treasurer, then vice president, and finally 3 years ago president. Her ascension coincided with a dramatic shift in the neighborhood's tone. Suddenly, community standards became the justification for a campaign of systematic harassment. Mrs. Gable, an elderly widow, was fined $200 because her mailbox, the same one that had been there for 8 years, was deemed an unapproved shade of forest green. The Patels were cited for having a religious ornament on their door that was visible from the street. A young family was ordered to remove a child's plastic slide from their backyard because it was taller than the fence line. Brenda's power was absolute because she wielded the HOA's governing documents like a weapon, interpreting them in the most draconian way possible. She held court at the monthly meetings, surrounded by a small clique of board members who were either too intimidated or too apathetic to challenge her. She was a performative tyrant, reveling in the public shaming of her neighbors over trivial matters. I was largely immune to it, as I wasn't technically in the HOA. My property predated it. But the access road, the only way into Oak Hollow, ran along the edge of my meadow. Over the years, a sort of informal understanding had developed. People would sometimes park on the grass during a party. The HOA's landscaping company would occasionally mow a 10-foot strip of it, mostly out of convenience. I never made an issue of it. It cost me nothing to be neighborly. That was my mistake. In Brenda's world, any ground ceded, no matter how informally, was territory conquered. Her campaign against me started subtly. A passive-aggressive note in my mailbox about my grass being too long in the meadow. An email suggesting I should contribute to the HOA's road maintenance fund. I ignored them. Then came the official-looking notices, printed on HOA letterhead, slid into my door. Notice of violation, unapproved landscaping. Final warning, unauthorized vehicle parking. They were nonsense, of course. She had no jurisdiction. But I didn't throw them away. I was a man who understood the value of a paper trail. I opened a new file folder, a simple manila one, and labeled it HOA. Into this folder went every notice, every email I printed out, every certified letter she sent that I signed for and then ignored. I kept the receipts. On paper, her harassment was building a beautiful case. A case for what, I wasn't yet sure, but I knew from decades in court that arrogance and paperwork are a combustible combination. Brenda was providing both in abundance. She was so convinced of her own authority that she was documenting her own overreach, signing her name to it, and mailing it directly to my house. It was, in its own way, a thing of beauty. The truck was the final straw for her. It was old, a bit dented, but it ran perfectly. I kept it parked in the meadow, far from the house, because the driveway was for Eleanor's old sedan, which I couldn't yet bring myself to sell, and my own daily driver. To Brenda, my truck was an eyesore, a symbol of my refusal to conform to her vision of suburban perfection. It was a personal affront. So she had it towed, and in doing so, she had finally escalated her campaign from paper-based harassment to a tangible act of theft and property damage. She had crossed a line from civil nonsense to a criminal matter. That morning, after Mike from County Line Towing had reluctantly hauled my truck away, and Brenda had departed with a final, gloating wave, I went back to my desk. I didn't call the police, not yet. The first call to authority in a property dispute is a delicate thing. You only get one chance to make a first report, and I wanted mine to be flawless. I pulled out the HOA folder. It was about an inch thick now. I smoothed out the latest notice, the one about the towing, and placed it on top. Then I picked up the phone. My first call was not to a lawyer. It was to my old clerk, Maria Rodriguez. She had retired a year after I did, but we'd worked together for 20 years. Her mind was as sharp as a box of freshly sharpened pencils. "James," she said, her voice warm, "to what do I owe the pleasure? Don't tell me you finally decided to digitalize your photo albums." "Something a bit more pressing, Maria," I said. "I need a favor. I need you to meet me at the county records office. We're going to pull some old plat maps, specifically the final plats for the Oak Hollow development." There was a pause. Maria knew me well enough to understand that a request like this was not made lightly. "Is everything all right, Judge?" she asked, the old honorific slipping out naturally. "Everything is proceeding in an orderly fashion," I replied. "Someone has made a procedural error, and I feel a professional obligation to correct it. Can you be there in an hour?" "For you, Judge, I'm already putting my shoes on," she said. The county records office was a place I knew intimately. It smelled of old paper, binding glue, and the faint metallic scent of microfilm machines. It was a library of facts, a cathedral of documented reality. While Brenda Miller was operating in a world of social pressure and perceived authority, I was about to go to the source code. We were fighting on different battlefields, and she didn't even know mine existed. I met Maria by the main counter. She was a small, bird-like woman, with eyes that missed nothing. She had a canvas tote bag slung over her shoulder, out of which peeked a legal pad and a box of highlighters. Old habits die hard. We didn't waste time with pleasantries. I gave her the parcel identification number for my property and the official name of the Oak Hollow subdivision. Within minutes, a clerk had wheeled out a trolley laden with heavy cloth-bound plat books and long, rolled-up survey maps. It was time to get to work. The first step was to establish a baseline. We unrolled the original survey of my 5-acre plot, dated 1997. The surveyor's marks were clear, the boundaries defined by metes and bounds, referencing old iron pins and oak trees that were still standing. We located the exact meadow area. The map was unambiguous. It was mine. That was the easy part. The harder part was proving a negative, that I had never, in any way, ceded control or granted an easement over that land to the HOA. That's where the Oak Hollow development records came in. When a developer creates a subdivision with an HOA, they file a master deed and a set of covenants, conditions, and restrictions, the C, C, and Rs. These documents legally define the boundaries of the HOA's authority. They specify which parcels are private property and which are common areas to be managed by the association. Brenda's entire case rested on her assertion that my meadow was one of these common areas. We spent the next 3 hours poring over the documents. Maria took the CC and Rs, her highlighter flashing as she tagged every mention of common areas, easements, and jurisdictional boundaries. I took the plat maps, the large-scale drawings that showed the entire subdivision. I started with the preliminary plats, the initial proposals the developer submitted to the County Planning Commission. On these early drafts, I found the first hint of the problem. A planner had made a handwritten note in the margin next to my property line. Request 15-foot public utility and access easement from adjacent parcel, my parcel number, for road maintenance and future sewer line. My heart beat a little faster. An easement would grant the HOA limited rights to use my land, which could, if interpreted creatively and aggressively by someone like Brenda, be twisted to include parking restrictions. I remembered the request now. The developer had approached me about it 20 years ago. We had negotiated. I had agreed, but under very specific conditions. I moved from the preliminary plats to the final recorded plat map, the one that, once signed and stamped by the county, becomes the legally binding document. I unrolled it on the large table under the fluorescent lights. Maria came and stood beside me. We scanned the page, tracing the lines of Oak Hollow, until we reached the border with my property. There it was. The 15-foot strip along the road was marked. But it was not marked as a public utility and access easement. The label, in crisp, official lettering, read, Future Development Setback. Parcel, my parcel number, not dedicated. Not dedicated, Maria read aloud, her voice soft with dawning realization. Well, I'll be. I felt a slow, cold wave of vindication wash over me. I remembered the final negotiation. The developer had been desperate to get the project approved. The sewer line issue was a potential holdup. I had agreed to the setback as a compromise. I would voluntarily refrain from building any permanent structures within that 15-foot strip, preserving it for a potential future sewer line if the county ever needed it. But, and this was the crucial point, I had explicitly refused to dedicate it as an easement. I had not granted anyone, not the county, not the developer, and certainly not the future HOA, any rights to access or control my land. It was a promise, a setback, not a transfer of rights. On paper, that strip of meadow was as much mine as the kitchen I had been standing in that morning. The HOA had likely been operating for a decade, under a collective misunderstanding, probably based on that early preliminary plat map. They had acted as if the easement existed. Their landscapers mowed it. Their president claimed it, but they had never checked the final, official record. Brenda, in her arrogant certainty, had built her entire case on a foundation of sand. She had no idea. But we weren't done. The absence of an easement was good. A bombshell would be better. I remembered something else from that time, the flurry of paperwork at the end of the project's approval phase. As a sitting judge, I wasn't directly involved in the Planning Commission's day-to-day work, but major development approvals, especially ones that required zoning variances, often crossed my desk for final review and signature. Oak Hollow had required several such variances. "Maria," I said, "pull the full permit file for the Oak Hollow subdivision. Everything, every application, every variance request, every letter of approval." An hour later, we had it. A thick stack of documents, brittle with age. We worked our way through it chronologically, and then, at the very bottom of the stack, we found it. It was the final development order, the master document that gave the green light for the entire subdivision. It listed all the conditions, all the required setbacks, all the approved variances. It was the birth certificate of Oak Hollow, and on the final page above the official county seal were two signatures. The first was the head of the Planning Commission at the time. The second, dated October 14th, 20 years ago, was mine. I had been the judge who reviewed and signed the order that legally created the very HOA that was now tormenting me. I had personally, with my own hand, approved the final plat map that explicitly stated the land was not dedicated. I looked at Maria, she looked at me. A slow smile spread across her face. "Judge," she said, "I believe this constitutes what we used to call an ironclad case." "I believe you are correct," I replied, feeling the weight of the last few years begin to lift. I took out my phone and took a high-resolution photograph of the plat map, paying special attention to the "not dedicated" label. Then I took a photo of the signature page of the development order. I requested certified copies of both. The paper trail was now complete. The folder was armed. My first move upon returning home was to compose a letter. It was not an angry letter. It was a formal, procedural notification of error. I addressed it to Brenda Miller in her official capacity as president of the Oak Hollow HOA, and to each member of the board individually. I sent it via email, with delivery and read receipts enabled, and also via certified mail. Return receipt requested. The letter was simple. It stated 3 facts. Fact 1. On the morning of August 12th, the HOA, at her direction, had illegally authorized the removal of my private property, a Ford F-150, from my own land, parcel number so-and-so. I included the name of the tow truck driver and his company. Fact 2. The land in question was not, and had never been, HOA common area. I attached a digital copy of the relevant section of the official recorded county plat map with the "not dedicated" label circled in red. I explained in clear, simple terms what "not dedicated" meant in the eyes of the law. Fact 3. I demanded the immediate return of my vehicle to its original location at the HOA's expense and full reimbursement for the towing and impound fees, for which I had already paid by credit card that afternoon to retrieve my truck. I attached a copy of the receipt. The total was $478. I gave them a deadline of 5 business days to comply. I concluded the letter by stating that if they failed to do so, I would pursue all available legal remedies to recover my costs, plus damages. I did not mention that I was the judge who signed their founding documents. That was a card to be played at a more opportune moment. Brenda's response was, in its own way, magnificent. It was a testament to the power of willful ignorance. She replied to my email a day later, copying the entire board. She did not address the plat map or the legal points I had raised. Instead, she wrote, "Mr. Henderson, we are all quite tired of your attempts to bully and intimidate the board with your so-called legal threats. The long-standing use of that area by the community establishes it as common ground. Regardless of what some old, dusty map says, we consider the matter closed. The vehicle was removed in accordance with the covenants, and any fees incurred are your own responsibility. Do not contact us again." She had no idea. She had just, in writing, admitted to receiving my evidence and chosen to ignore it in favor of a legally meaningless concept she called long-standing use. She had confessed to a deliberate act, not an accidental one. I printed her email and placed it in the folder. It was a beautiful piece of evidence. The certified letters were returned to me a week later. The board members had all signed for theirs. Brenda's had been refused. Another beautiful piece of evidence, a deliberate refusal to receive a formal notice. Now it was time for the next step. I went to the hardware store and bought 4 sturdy metal posts and a professionally printed sign. The sign read, in large block letters, "Private property, no trespassing. Violators will be prosecuted. Oak Hollow, HOA, has no jurisdiction or authority beyond this point." I hammered the posts into the ground along the exact 15-foot setback line shown on the survey map, creating a clear physical demarcation. I hung the sign in the middle. The meadow was now visibly, undeniably claimed. It took less than 24 hours for this to provoke the next escalation. The following Saturday, I was in my workshop when I heard a commotion. It was Brenda, of course. She was standing at the sign, phone pressed to her ear, speaking in a loud, frantic voice. I could hear snippets. Completely unhinged, putting up threatening signs. I feel unsafe. 10 minutes later, a sheriff's department cruiser rolled up. A young deputy stepped out, looking calm but cautious. This was the moment I had been preparing for. Brenda launched into her performance. She was the picture of a concerned community leader, besieged by a hostile and irrational resident. She claimed the sign was on HOA property. She claimed I was trying to intimidate her. She implied I was dangerous. The deputy listened patiently, nodding in all the right places. Then he turned to me. I had walked out to meet him, holding a slim portfolio. "Sir," he said, "can you tell me what's going on here?" "Certainly, deputy," I said calmly. "My name is James Peterson. This is my property. That sign marks my property line. I put it there to prevent further trespassing by this individual and the organization she represents, the Oak Hollow HOA." "That's a lie," Brenda shrieked. "This has always been common area." The deputy held up a hand. "Ma'am, let me speak with him. Mr. Peterson, do you have any documentation to support your claim?" This was the question I had been waiting for. This was the moment where performance collides with paper. "I do," I said. I opened the portfolio. I did not show him my entire folder of evidence. That would be overwhelming and inappropriate. I showed him only 2 documents. The first was the deed to my house, which clearly stated the size of my parcel. The second was the certified copy of the official county plat map, which clearly showed the boundary line and the not dedicated status of the meadow. The deputy was young, but he was not stupid. He knew how to read a plat map. He took the document and studied it for a long moment, his eyes tracing the lines. He walked over to the corner of my property, where the original surveyor's iron pin was still visible in the grass, and compared it to the map. He looked back at my sign, then at Brenda. His entire demeanor shifted. The cautious neutrality was replaced by a look of weary comprehension. He had seen this movie before. "Ma'am," he said, turning back to Brenda, "based on the official county documents this gentleman has provided, this sign appears to be on his property. This is a civil matter regarding a property dispute. It is not a criminal matter. There is no threat here. He has a right to post signs on his own land." Brenda's face turned a blotchy red. "Are you taking his side? I am the president of the Homeowners Association. I represent 50 families. He's just one man." "Ma'am," the deputy said, his voice now cold and official, "I am not taking anyone's side. I am telling you that based on this evidence, you are the one standing on his property. I would advise you to return to your own property now." He then turned to me. "Sir, for my report, can you confirm your full name and date of birth?" I provided them. "And deputy," I added, "could you please note in your report that I presented you with the official recorded plat map, and that Miss Miller was advised that she was trespassing on my property?" "I will," he said, giving me a brief, almost imperceptible nod. He understood. I wasn't just talking to him. I was building a record. He handed me back my documents, gave Brenda one last warning look, and returned to his car. The deputy's visit was a turning point. It was the first time Brenda's authority had been publicly and officially contradicted. It didn't stop her, but it weakened her. More importantly, it was witnessed, and that's when the first crack in her wall of support appeared. That evening, my doorbell rang. It was my next-door neighbor, a quiet man named Arthur Henderson. Ironically, the very name Brenda had been calling me. Arthur was a retired accountant, a widower like myself, who had lived in Oak Hollow since it was built. He was one of Brenda's favorite targets. She had fined him repeatedly for the state of his lawn, which he struggled to maintain due to a bad back. He stood on my porch twisting a worn corduroy cap in his hands. "Mr. Peterson," he began, his voice low. "I saw what happened today, with the sheriff. I wanted to say thank you." "There's no need to thank me, Arthur. I was simply protecting my property." He shuffled his feet. "No, it's more than that. You stood up to her. Nobody does that. We're all too scared of the fines, of the hassle." He took a deep breath. "I have something that might help you, if you're, planning on taking this further." He had my full attention. I invited him in, and we sat at my kitchen table. From his pocket, he pulled a small, digital audio recorder. "I started recording the HOA meetings a year ago," he confessed, "after she humiliated me in front of everyone over some dandelions. I just wanted a record, in case she lied about what was said." He pressed a button on the device. A tinny recording of Brenda's voice filled the room. It was from a board meeting 2 months prior. Another member was questioning the aggressive stance on parking along my property. Brenda's response was chillingly clear. "Look," her recorded voice said, "I've seen the old maps. It's fuzzy, but the lawyers say that if we act like it's ours, if we enforce our rules on it consistently, then over time it becomes ours. It's called adverse possession or something. We establish a precedent. That's why we have to tow the old man's truck. It's the exclamation point on our claim. We just have to be aggressive and not back down." I looked at Arthur. He had just handed me a smoking gun. This wasn't a misunderstanding based on an old map. This was a deliberate, calculated strategy to seize control of my land, based on a half-baked and legally incorrect interpretation of adverse possession, a doctrine that, in our state, cannot be applied against a property owner who is aware of the encroachment. Brenda had confessed, on tape, to acting in bad faith. "Arthur," I said, my voice filled with a gratitude that surprised me, This is invaluable. You've shown remarkable courage." He just nodded, a look of profound relief on his face. He was the fearful ally, and he had just delivered the prosecution's Exhibit A. 2 days later, the second crack appeared. I received an anonymous email. The sender's address was a jumble of letters and numbers. The message was short. "I am on the HOA board. I am tired of Brenda's bullying. She is running this association into the ground. She is going to hold an emergency meeting to vote on placing a lien on your property, for the towing fees and for damaging common area by installing your sign. The meeting is a sham. She's already pressured the votes she needs." Attached are the unofficial minutes from the last 3 meetings she held at her house, not at the clubhouse. Be careful. Attached was a PDF. It contained minutes that detailed Brenda's campaign against me, including her directive to the HOA's lawyer to find any way possible to claim my land. The disillusioned insider had come forward. I now had proof of a conspiracy. The folder on my desk was no longer just a collection of documents. It was an indictment. Brenda's final escalation came exactly as the email had predicted. A week later, another certified letter arrived. It was a formal notice from the Oak Hollow HOA. They had held an emergency meeting and, in accordance with the bylaws, had voted to levy a special assessment against my property for $5,000. This included the $478 for the tow, fines for unauthorized signage, and legal fees incurred by the association in dealing with my continued belligerence. The letter stated that if the amount was not paid within 30 days, a lien would be placed on my property. It was a breathtakingly stupid move. Filing a fraudulent property lien is a serious offense. It's called slander of title. She had just handed me a cause of action that could not only dismantle her case, but could also expose her and the board to significant personal liability. She was trying to use the threat of a cloud on my property title, one of the most powerful weapons in an HOA's arsenal, to crush me. She thought it was checkmate. It was, in fact, a catastrophic blunder. I picked up the phone and called a man named David Chen. David had been one of my best law clerks 20 years ago. Now he was one of the most feared civil litigators in the state. "Judge Peterson," he said, his voice instantly respectful. "It's been too long." "David," I said, "I have a small civil matter I'd like you to look at. It involves a fraudulent lien, a conspiracy to commit trespass, and a rather colorful cast of characters. I believe you'll find it entertaining." I spent the next hour walking him through the contents of the folder. I could almost hear him smiling through the phone. When I got to the part about my own signature on the development order, he let out a low whistle. "Oh, this is better than entertaining, Judge," he said. "This is poetry." The final confrontation was set for the HOA's annual meeting, held in the clubhouse. The lien had not yet been filed. They had to wait the 30 days, but the assessment was the talk of the neighborhood. The atmosphere in the room was thick with tension. The space was packed. On one side sat Brenda's loyalists, looking smug and self-righteous. On the other side were residents I'd never spoken to, people who had been fined or harassed over the years, who looked at me with a mixture of hope and fear. Arthur Henderson sat in the front row, looking nervous but resolute. The disillusioned board member, a young woman I now knew to be Sarah Jenkins, sat at the board table, her face pale and set. Brenda, at the podium, was in her element. This was her stage. She began with a rehearsed, emotional speech. She painted a picture of a peaceful, harmonious community besieged by a single, selfish individual who refused to play by the rules. Her voice trembled with manufactured sincerity as she spoke of protecting property values and ensuring the safety of their children. She portrayed herself as the victim, a volunteer leader working tirelessly for the good of the community, only to be met with hostility and legal threats from an outsider. She spoke of the frivolous maps and the aggressive signs, twisting every fact to fit her narrative of my villainy. It was a masterclass in performative victimhood. When she finished, there was a smattering of applause from her section. She smiled, a look of serene confidence on her face, and then said, "The floor is now open for discussion on the special assessment against the non-member property at 121 Creek Road." David Chen rose from his seat beside me. He was impeccably dressed, calm, and radiated an aura of quiet, lethal competence. "Madam President," he said, his voice filling the room without effort, "my name is David Chen. I represent the owner of that property, Mr. James Peterson." A murmur went through the room. Brenda's smile tightened. She hadn't expected me to have a lawyer of David's caliber. "This is a community meeting, not a courtroom," she snapped. "Lawyers are not necessary." "On the contrary," David replied smoothly, "when an organization is attempting to illegally assess fees and file a fraudulent lien, a lawyer is not only necessary, it is essential. My client will not be speaking. Instead, with your permission, I would like to present a few documents for the board's and the community's consideration." He didn't wait for permission. He walked to the front of the room and placed a projector on a small table. The first image that flashed on the screen was a copy of the certified letter I had sent, the one Brenda had refused. The second was a copy of her email, dismissing the plat map as old and dusty. The third was the sheriff's report, with the deputy's conclusion that I was within my rights and she was the one trespassing. With each slide, David provided a calm, factual explanation. The mood in the room began to shift. The smug looks on Brenda's supporters began to fade. Then, David said, "Now I'd like to play a short audio clip for you." He played the recording Arthur had given me. Brenda's voice, tinny and conspiratorial, filled the silent room. "The lawyers say that if we act like it's ours, we establish a precedent. That's why we have to tow the old man's truck." A collective gasp went through the audience. People turned to stare at Brenda. Her face, which had been flushed with confidence, was now ashen. The mask of the benevolent community leader was cracking. "This recording," David announced, "demonstrates that this was not a simple misunderstanding. This was a deliberate, bad faith attempt to seize private property. This, members of the board, is a conspiracy to which you have all been made a party." He looked directly at the other board members, one by one. Two of them refused to meet his gaze. Sarah Jenkins, however, looked back at him and gave a single, firm nod. And finally, David said, his voice dropping slightly for dramatic effect, "Let's address the old, dusty map." He projected the official county plat map onto the screen. He used a laser pointer to trace my property line, and then circled the words, "Not dedicated," in bright red. "This is not just a map. This is the legally binding document that defines your entire subdivision. It is the source of your authority, and it explicitly states that the HOA has no authority over my client's land." He paused, letting the image sink in. Brenda, cornered and desperate, finally spoke. That document could be fake. It's ancient. The rules we operate under now are what matter." "An excellent point, Madam President," David said with a predatory smile. "You are questioning the document's authenticity. You are questioning its authority." He clicked to the next slide. "Perhaps you'll recognize the authority of this document." On the screen appeared the final page of the Oak Hollow Development Order, the birth certificate of her power. David's laser pointer moved to the bottom of the page, to the two signatures. "This is the order that created the Oak Hollow subdivision, and this very HOA," David said, his voice resonating with finality. "And this," he circled the second signature, "is the signature of the Superior Court judge who reviewed the petitions, verified the plat maps, and gave this development its legal life. The judge who signed this order, Madam President, was, at the time, the Honorable James T. Peterson." He turned the laser pointer from the screen and aimed it directly at my chest. I sat there perfectly still, my hands folded in my lap. Silence. A profound, absolute silence descended on the room. Every eye swiveled from the signature on the screen to me, then to Brenda. Her face was a ruin. The color had drained from it completely, leaving a waxy, slack-jawed mask of disbelief. The arrogance, the confidence, the self-righteous fury, it all evaporated in an instant. The mask didn't just crack, it shattered into a million pieces. In that moment she finally understood. She hadn't been fighting some stubborn old man. She had been fighting the very legal foundation of her own existence. She had picked a fight with the law itself, and the law had just shown up in the form of a quiet man who had kept all the receipts. The collapse was total and instantaneous. She opened her mouth, but no sound came out. She just stood there, clutching the podium, a monument to her own spectacular miscalculation. The aftermath was swift and decisive. In the stunned silence of the clubhouse, Sarah Jenkins, the disillusioned insider, stood up. "I move for an immediate vote of no confidence in our president, Brenda Miller," she announced, her voice clear and strong. Arthur Henderson seconded the motion. The vote was a landslide. Brenda was stripped of her title right there, in front of everyone she had lorded it over for years. She stumbled away from the podium without another word and fled the clubhouse. The next day, David Chen sent a formal demand letter to the HOA's legal counsel. It was a masterpiece of legal devastation. It demanded the immediate rescission of the $5,000 assessment, a formal, written apology to me, and full reimbursement for all my costs, including David's legal fees. But it went further. It laid out the grounds for a civil lawsuit against the HOA for slander of title, conspiracy and trespass, and against Brenda personally for breach of fiduciary duty. It noted that, given the evidence of bad faith, the board members' liability insurance would likely not cover them, leaving them personally exposed. The HOA's lawyer, a man who clearly had no idea of the hornet's nest Brenda had kicked, called David within an hour. The capitulation was total. The assessment was voided. A check for my towing fees and David's legal bill was messengered to my house that afternoon. A week later, a formal letter of apology, signed by the entire new board, arrived in my mailbox. The healing in the community began almost immediately. With Brenda gone, a sense of relief seemed to settle over the neighborhood. Sarah Jenkins was elected the new HOA president. Her first act was to call a special meeting to review all outstanding fines and violations issued under Brenda's tenure. Nearly all of them were dismissed. Mrs. Gable got a letter informing her that her forest green mailbox was now considered a charming aesthetic choice. The Patels were told their door ornament was a welcome expression of cultural diversity. Checks were mailed out, refunding years of petty fines. People started talking to each other again. The atmosphere of fear and suspicion evaporated, replaced by a tentative neighborliness. Brenda Miller and her husband put their house on the market a month later and moved away. I heard she had to pay a hefty settlement to the HOA's insurance company to avoid being sued by them personally for her reckless actions. She lost her throne, her social standing, and a significant amount of money. She had built her kingdom on a foundation of paper-thin authority, and a single, authentic piece of paper had brought it all crashing down. Now, months later, peace has returned to my 5 acres. My old Ford F-15 sits in the meadow, exactly where it was before, a silent testament to the battle fought and won. The private property sign is still there, not as a gesture of aggression, but as a quiet reminder of the importance of boundaries, both physical and legal. Arthur Henderson and I have become good friends. We have coffee on my porch some mornings, and I help him with his yard work. Sarah Jenkins occasionally stops by to consult on procedural matters for the HOA, a role I am surprisingly happy to fill. I keep the HOA folder in the bottom drawer of my desk. It is thick and heavy with documents. The notices, the photos, the certified letters, the plat maps, the audio transcripts, the court order bearing my own name. It's a tangible history of a conflict I never wanted, but was uniquely prepared to win. Sometimes I take it out and look at it. It reminds me that justice is not always a thunderous affair of dramatic courtroom confessions. Sometimes it is a quiet, methodical process. It is the patient accumulation of facts. It is the simple, unassailable power of a signature on a piece of paper, a truth recorded and preserved, waiting for its moment to be brought into the light. This morning, I sat on my back porch, a cup of coffee in my hands, Buster dozing at my feet. The sun was rising, casting a warm glow on the meadow. A young family from down the street was walking by on the access road, and their little boy waved at me. I waved back. The air was filled with the sound of birds, not beeping tow trucks. It was the quiet I had fought for, the order I had restored. It was the deep, long exhale of a peace that was not just given, but earned. On paper, and in fact, this land was mine. And finally, it felt that way again.